Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and today on the docket, a Patrick Frazee update, and I have said it once and I will say it again. It's the defendant's own words that come back and bite him. Second, a tragic case out of Atlanta. Third, Photos Dulos wants to keep talking. His attorney is challenging a gag order. And finally, where is my extra cheese? The famous words of the Dumb Criminal of the Week contestant. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk. We are coming to you on Veterans Day. For those who have served, we say thank you. For all the spouses and children of those who have served, we say thank you because their service wouldn't be possible without yours. First on the docket today, I have said it once and I have said it 1,000 times. It is always the defendant's own words that come back and bite them. And in the Patrick Frazee trial late Friday afternoon, it looks like that is what's coming back and is going to potentially hurt Mr. Patrick Frazee. For those who don't know, Patrick Frazee is charged with killing his one-time fiancée, Kelsey Barrett, the mother of their child. And it is alleged that Patrick Frazee's other one-time on-again, off-again girlfriend, who clearly wanted to be with Mr. Patrick Frazee, was solicited once to poison Kelsey Barrett's coffee. Two, was sent to her condo with a pipe, stating, according to Miss Crystal Lee Kenny, the nurse, the other girlfriend, was that she should hit her and not make it too big of a mess. And then the third time, apparently Patrick Frazee gave her a bat and said, swing away. And ultimately, Crystal Lee Kenny says that she never went through on any of those attempts. Ultimately, Crystal Lee Kenny, the other girlfriend, the nurse, drives from Idaho basically on Thanksgiving Day and drives out to, quote, clean up a mess because Patrick Frazee says he's made a mess and she needs to come clean it up. Kelsey Barrett is ultimately reported missing by her mother. The search ensues. Nothing is found. Patrick Frazee is charged with first-degree murder. Crystal Lee Kenny is charged via a plea to tampering with evidence, a Class 6 felony, a very low charge here in Colorado, where she faces only a presumptive range of 12 to 18 months in prison or up to 3 years if it is in an aggravated range, and she has agreed to that range. So she could get probation up to 3 years and then a 1-year period of parole. Not pretty significant for basically someone that conspired with Patrick Frazee, allegedly, to kill Kelsey Barrett. Now, we had discussed all of this, but late Friday afternoon, there was a witness by the name of Joseph Paul Moore. And Joseph Paul Moore has known Patrick Frazee for a long time. Joseph Moore said a couple of things Friday which lends great credibility to him. One, he considered Patrick Frazee a friend. Two, he stated that he didn't want to think that somebody that he knew could actually do something that Mr. Frazee is accused of. But he recollected two conversations where he had conversations with Patrick Frazee regarding Kelsey Barrett. And one conversation, he says, oh, I want to get rid of her, kill her, and he kind of trails off. And then Mr. Moore states that it trailed off and he didn't really follow up. But at one point in April of 2018, he asked Patrick Frazee how things were doing, and apparently he says, I figured out a way to kill her. Mr. Moore says, hey, you don't joke about stuff like that, and that's just, don't do those types of things. There was also a recollection of a conversation that they had where basically, if there's no body, there's no case. If there's no face, there's no case. We've talked about that before. Why? Because identity is so important in a criminal trial. They need to show that the defendant is the one that actually did something wrong. Unlike say, for example, an assault case or a domestic violence assault case, where somebody comes in and points their finger and says, yes, the man at the defendant's table is the one that did blank to me. hit me, pushed me, poked me, shoved me, whatever. In a murder case, obviously that's more difficult when you don't have a victim coming in and testifying. So it comes from a lot of evidence that comes in from other people. And a lot of this is circumstantial. The conversation with Mr. Moore was, and then what came up apparently during the testimony, is that they would kind of kid and joke about, oh, women, you can't divorce them, you can't kill them, those types of things. Banter, completely, inappropriate. Was it just joking? Possibly. But this is what I want to talk about when it comes to statements, and anything the defendant says can and will be used against you, okay? I had a lovely subscriber the other day that made a comment regarding, I made a suggestion that it was probably inappropriate for the mother of Kelsey Barrett to testify as to what her daughter was saying. Well, because that is hearsay, okay? Hearsay. It's an out-of-court statement of another person that someone on the witness stand is testifying to, being offered for the truth of the matter asserted. So someone on the witness stand cannot testify to what someone else said that has not come to court and testified already. That's a general rule of hearsay. Yes, there are many, many exceptions. Oftentimes the district attorney will say, well, it's not being offered for the truth of the matter asserted. Okay. So, for example, if the conversation is, officer, what did the witness say to you? Sometimes the judges will allow it in. Others will say no. From the defense perspective, if it's not being offered for the truth of the matter asserted, then why is it relevant? A good judge will usually just say, just ask the witness without saying what was said. Was there a conversation? Yes. What did the officer do after that conversation based upon that conversation? He then pursued a lead or something to that effect. So just because Kelsey Barrett said it to her mother does not make it a non-hearsay statement, okay? But statements that do come in, okay, it's called admissions of a party opponent. And if you are a defendant, anything that you say can and will be used against you because it comes in as a statement against you. You're a party to the proceedings. And so if Patrick Frazee said these things and his friend thinking, oh, I don't think it's going to hurt, I'll probably never come to court, he can be forced to testify as to what things said. Now, these statements could have been in jest, maybe not, but clearly that's for the jury to decide whether they come in or not, but they come in because there were statements by Patrick Frazee, the defendant. Oftentimes people think, and I've had many clients think, that somehow they only believed that what they told the police after being advised of the Miranda rights should come in. Not the case. Anything a defendant says to anyone can be used against you. Even family members could be forced to come in and testify against a defendant. And it looks like that's what's going to happen here in Mr. Patrick Frazee's case, is all these people that he talked to, and whether it was in jest or whether he was serious about killing Kelsey Barrett, that's ultimately for the jury to decide whether it's credible or just inappropriate bantering. So we shall see, but I think things are starting to get, the piling on is coming. Additionally, there was discussion generally about the remains of a tooth, and it was referenced a few times as a human tooth. Normally, the prosecutors aren't going to bring that type of information up unless they have some testing. So although we have not had a witness come and testify as to the tooth, why they believe it's A, a human tooth, and B, whether in fact is Kelsey Barrett's tooth, is that they need to lay the foundation of bringing in the people that did the testing to ultimately determine how, in fact, they determined it was Kelsey Barrett's tooth or not, or was this just a tooth they found out in the field that could have been a cow's tooth? You never know. We'll just have to wait and see on that one. But I think things are starting, the piling on is coming, and it's going to be curious to see whether Patrick Frazee ultimately takes a stand in his own defense, and maybe he'll say Crystal Lee Kenny is the one that did it. In fact, I helped her dispose of the body because I was trying to help her out, and who knows that she's the real murderer, so to speak. Now, of course, The defense cannot put Patrick Frazee on to say something like that if he's already told them what may have happened. If he says, yes, I did it, his defense attorneys cannot put him on. He will have to sit there silently. If he's never told them or always maintained, I didn't do it, it was, for example, say Miss Kenny, then he could obviously get up and testify, and the attorneys would not be ethically prohibited from allowing him to get up and do that. So we'll wait and see. Court's in recess today because of the Veterans Day holiday. It shall resume this week and probably be over by the end of the week or early next, but we'll see. The next case on the docket is a case out of Atlanta. The victim is a young college student who's 21 by the name of Alexis Crawford. And the two suspects in this particular case are Jordan Jones, 21, and her boyfriend, Baron Brantley, who's also 21. They're both being held for investigation of murder. What makes this tragic is that Alexis Crawford, the victim, and Jordan Jones were roommates in college. Jordan Jones had actually spent time with Alexis Crawford's family over holidays and basically trips home from school. We'll have to see where this goes, but apparently one of the two suspects, and understand they are suspects, led police authorities to the body of Alexis Crawford. And Miss Alexis Crawford went missing 5 days after she made a report alleging that Baron Brantley, the boyfriend of her roommate, made advances toward Miss Crawford in the form of unwanted kissing and touching. But it was obviously alarming enough that she actually went to the police. As of right now, the cause of death appears to be asphyxiation, and we will have to see, of the two suspects, Jordan Jones and Baron Brantley, which of the two actually did it. Was there a conspiracy? Was it one person who did something out of a heat of passion and one helped to try and cover it up, or were they both equally as culpable? Tragic case. We'll see where it goes. The next case on the docket is the case that we have talked about from Connecticut, and that is the case of Fotis Dulos. Although he's not been charged, he is considered by the police the lead suspect in the disappearance of his wife, Jennifer Dulos, who is the mother of their 5 children. The court in this particular case issued a gag order, and the gag order prevented both sides from discussing the case, and it prohibited basically all parties related to the child custody and divorce proceedings from discussing the case. Now, Mr. Dulos' attorney, Mr. Pattis, would have nothing to do with this. And Fotis Dulos has been accused of basically violating this protection order, this gag order, by giving interviews and discussing the case. And Mr. Dulos' attorney, Mr. Pattis, wants to be able to defend his client in the court of public opinion. So he is appealing to the Connecticut Supreme Court to try and have this overturned, saying that it is unprecedented and it is a restraint on speech. Some of the newspapers in the area have also filed what they refer to as an amicus curiae brief, saying that this is basically prior restraint and that basically no one should be allowed under this court's order to talk about this case. Attorneys have a right to represent their defendant and to speak to the press, but ethically they technically are not supposed to be out there doing things that are misleading, false, or in any way that could hinder the fair administration of justice. Now, does that mean that a defendant cannot go talk about his case or not give an interview? No. Does that mean an attorney cannot get up there and say, I am defending my client, he is not guilty, and can get into the specifics of it? Yes, he can. It's really on a case-by-case basis. As a defense attorney, I can tell you, oftentimes you do not want to go try your case in the press, particularly if you are trying to resolve it quietly. You want it to go away. In this particular case, it looks as though Fotis Dulos and his attorneys have declared absolute war, and there will only be one resolution, which is either the filing of charges or no charges filed at all. Nothing will be acceptable to them. What Fotis Dulos' attorney, Mr. Pattis, is alleging, though, is that he's being prohibited from presenting facts about this particular case that shows his client's innocence. In the meantime, the prosecution is releasing affidavits for arrest warrants, some 43 pages, outlining various things that are very one-sided and don't provide any exculpatory evidence as it relates to the fact Mr. Photo's doulos could not have committed the crime because on the date of the crime he was not even in the city, and apparently he has an alibi which was turned over, but the prosecution is not releasing that information to the general public. So I get Mr. Pattis's argument saying, hey, prosecution, you want the gag order, then don't release this information, or at least if you're going to do it, release all of it. It's going to be interesting to see how the court ultimately rules on this. Courts are given broad discretion when it comes to the cases like this, and I think what it's going to ultimately come back to is the court's going to rule that the attorneys should be governed by the rules of ethics, and they can't say anything that basically is misleading, that is untrue, that will unfairly taint the potential jury pool. We'll see how it comes out, but I think Mr. Pattis will not be making a whole lot more TV appearances on behalf of his client because of that. The next matter on the docket today is our daily contestant for the Dumb Criminal of the Week. And this contestant comes to us from Wisconsin. Where's my extra cheese? This unidentified man in Wisconsin goes to a Pizza Hut, orders a personal pan pizza, and requests extra cheese. He receives his pizza, goes outside or leaves, and comes back about 5 minutes later with his girlfriend, who say that the cheese pizza doesn't have enough extra cheese. The employees at Pizza Hut state, I could make you a new one, but basically we measure the cheese, and so the extra cheese is still going to be the same amount whether I make you a new one again. This unidentified Wisconsin man at this point becomes enraged, starts yelling, enough to the point where the employees ultimately called the police. The unsatisfied customer leaves with his girlfriend. When the police arrive, he is gone. This unidentified man is contacted by the police. He denies threatening anybody. He denies raising his voice in any way. He was just simply upset by the cheese pizza being insufficient in quantity of extra cheese. And he also uttered some words about being concerned that the Pizza Hut employees would spit in his food, which is why he rejected the extra pizza and threw away the original insufficient pizza. So now this gentleman gets to go to court for disorderly conduct, has to probably retain an attorney to defend himself because he couldn't just let the pizza go. This unidentified Wisconsin man is our Dumb Criminal of the Day contestant for the ultimate prize at the end of the week. But the moral of this particular story is let it go. Not everything has to be a war. Not every altercation do you have to burn the house down. Maybe just kick in the door a little bit every now and then, or just let it go. It's a cheese pizza. Let it go. Thanks for watching. If you have not already subscribed to our channel, we would ask that you hit that subscribe button. If you like the video, leave us a comment below, and also please hit that like button. Hit that little bell so that you receive notifications of when we go live or put up new content. That's all that we have for you today on Crime Talk. Have a great day.